San Quentin's last-minute mercy, the hidden psychology behind death row clemency. Inside the concrete perimeter of San Quentin State Prison, where the Justice Department once recorded some of the most studied capital cases in modern U.S. history, decisions made in the final hour often contradict months or years of legal certainty. Clemency here is rare, controversial, and psychologically destabilizing for everyone involved. And yet, it is in these last-minute requests that the true fault lines of the American justice system are exposed. This documentary contains descriptions of prison conditions and violence for educational purposes based on verified sources. Viewer discretion is advised. For more deep research of prison documentary like this, don't forget to like, comment, and subscribe. This documentary examines the psychological mechanics behind clemency petitions on death row, focusing on San Quentin's well-documented legal environment, its structured appeals process, and the emotional volatility surrounding final decisions. Drawing from verified sources, including the California Department of Corrections and Rehabilitation, the American Psychological Association, the National Institute of Justice, and academic analyses from researchers such as Craig Haney and Irving Irwin, we explore how individuals and institutions confront choices that carry irreversible consequences. This is not a story about sensational cases. It is about the mental strain, behavioral shifts, and legal pressures that define the closing moments of a clemency battle. The stakes are absolute, but the motivations are deeply human. The invisible clock. How time pressure shapes clemency decisions. Time functions differently on death row. Experts in legal psychology, such as the APA's Forensic Division, have long established that extreme time pressure distorts judgment, narrows focus, and amplifies emotional reactivity. In San Quentin, these psychological effects are not theoretical. They are observable, documented, and embedded in the institutional history. Attorneys working on clemency petitions describe a compression effect. As the execution date approaches, decision-makers exhibit sharper cognitive rigidity. The National Institute of Justice's studies on high-stress legal environments note that officials under time constraint are more likely to default to established policy rather than reconsider evidence, especially when new information emerges late in the process. For inmates, psychologists like Craig Haney have documented a distinct behavioral pattern. Quiet withdrawal, heightened vigilance, disrupted sleep, and sharp fluctuations in hope versus resignation. These shifts affect how inmates engage with their legal teams, how they respond to new evidence, and how they communicate with family members during last-minute appeals. One nonfiction case frequently cited in criminal justice literature involves an unnamed San Quentin inmate whose mitigation evidence, including cognitive impairment, documented in medical reports later reviewed by external psychologists, was not fully evaluated until the final week of appeals. Although the case details remain anonymized in academic publications for privacy, the documented psychological dynamics are clear. The inmate cycled between bursts of engagement with counsel and periods of emotional shutdown, a pattern consistent with APA findings on stress-induced cognitive overload. Within the institution itself, correctional staff experience their own version of the time pressure effect. Irving Irwin's research on prison subcultures highlights the emotional compartmentalization required in high-stakes environments. Staff report a dual obligation, maintaining strict operational control while managing the unpredictable psychological reactions of individuals confronting a possible last-minute reprieve. The result is a countdown where every hour amplifies uncertainty, and where the possibility of clemency, however small, changes the psychological landscape for everyone involved. The governor's dilemma, political pressure and human judgment. The power to grant clemency in California rests with the governor, a role that blends legal authority with intense public scrutiny. According to the California Constitution and summarized in CDCR public materials, a governor may commute a death sentence only under strict procedural guidelines and, in some cases, with the approval of the state's Supreme Court. This process creates a uniquely pressured decision environment where legal prudence intersects with political risk. Political scientists and legal scholars note a consistent phenomenon. As execution dates approach, governors face heightened pressure from multiple sides, advocacy groups urging reconsideration, victims' families seeking closure, and public opinion demanding accountability. The National Institute of Justice has published several analyses showing that high-profile capital cases amplify these pressures, narrowing the decision-making bandwidth of public officials and pushing them toward choices that minimize political fallout rather than maximize fairness. Psychologically, this environment induces what researchers call anticipatory accountability. Faced with public evaluation before a decision is even finalized, governors may become more cautious, more reliant on established protocols, and less willing to engage deeply with nuanced late-stage evidence. This is consistent with APA findings showing that leaders under anticipatory scrutiny demonstrate reduced cognitive flexibility. Inside San Quentin, attorneys preparing late clemency submissions understand this dynamic. They construct petitions that highlight new mitigating factors such as trauma histories, mental health evaluations, or forensic errors, elements supported by verified sources like the Innocence Project and the Chicago Crime Lab, both of which have documented how cognitive impairment, flawed investigative procedures, and unreliable witness testimony have historically altered the outcomes of capital cases. A well-documented San Quentin case, frequently referenced in legal scholarship, involved a petition built around neuropsychological evaluations conducted at the 11th hour. These assessments, conducted by licensed forensic psychologists and later summarized in academic reviews, revealed significant cognitive deficits that had never been presented during sentencing. Although anonymized in publications, the case demonstrates a recurring pattern. Evidence that emerges late forces the governor into a decision window that is psychologically compromised by time, politics, and public expectation. Staff within the governor's legal office described the internal atmosphere during final reviews as analytical triage, a phrase that appears in multiple interviews archived by justice-focused research centers. Each new document must be evaluated rapidly yet thoroughly, knowing that a misjudgment carries irreversible consequences. But the gravity of the situation does not mean the process is arbitrary. Governors rely on structured frameworks, the verified psychological assessments, institutional conduct reports, a legal analysis of procedural fairness, a victim impact statements, forensic evidence summaries, recommendations from independent review boards. Still, even with these supports, the ultimate decision requires a form of psychological endurance that few public roles demand. In this fragile decision space, clemency becomes more than a legal action. It becomes a test of how human judgment holds under extraordinary pressure. The defense team, strategy under extreme constraint. 4 defense attorneys working inside San Quentin's capital litigation environment. The final phase of a clemency petition becomes a psychological and operational sprint. The American Psychological Association notes that legal teams under high-stakes, time-limited conditions often experience cognitive tunneling, a mental state where attention narrows to only the most urgent tasks, sometimes at the cost of broader strategy. Capital defense units understand this risk intimately. Once an execution date is set, every hour must be used to identify new mitigating evidence, refine psychological evaluations, or correct procedural inconsistencies. The National Institute of Justice has repeatedly documented that late-stage forensic reviews sometimes reveal oversights previously impossible to detect due to outdated testing methods or incomplete investigative resources. In San Quentin, linked case studies referenced in law journals, defense teams frequently describe the final stage as a cycle of rapid coordination. Neurological experts confirming cognitive impairments, trauma specialists reviewing medical histories, and legal analysts verifying whether emerging evidence aligns with constitutional standards for clemency. Although the identities of inmates in these case studies are anonymized for ethical reasons, the behavioral patterns observed across cases are consistent. A representative example cited in NIJ-supported research involved a San Quentin inmate whose defense team discovered previously overlooked records of early life neurological trauma. Forensic psychologists brought in at the last moment identified symptoms aligned with APA's criteria for cognitive vulnerability. This discovery transformed the legal team's strategy, shifting the petition from procedural arguments to a focus on human factors, developmental psychology, and long-term impairment. but the psychological strain on the attorneys is as significant as the legal challenge. Interviews documented by criminal justice researchers reveal that defense teams often experience disrupted sleep cycles, heightened vigilance, and an acute sense of moral responsibility. One attorney described the atmosphere as relentless triage, a phrase independently echoed in several published accounts of defense work in capital cases. Within this environment, communication with the inmate is a critical yet fragile component. Craig Haney and other researchers note that many individuals on death row develop coping patterns that influence how they interact with their legal teams during intense periods. Some become hyper-engaged, requesting constant updates. Others withdraw, unable to maintain emotional stability as the deadline approaches. For the attorneys, this variability adds another layer of complexity. They must balance the inmate's emotional state with the need to extract accurate personal histories, secure signatures, or review last-minute evaluations, all while maintaining professional clarity. The defense team's work represents a convergence of psychology, law, and human endurance. The closer the deadline moves, the more every small discovery feels decisive, even when the outcome remains uncertain. The inmate's mind, hope, resignation, and the psychology of extreme uncertainty. Life on San Quentin's death row imposes a psychological environment that researchers such as Craig Haney have consistently described as uniquely destabilizing. But when clemency becomes a real possibility, however slim, the inmate's mental landscape shifts into a pattern documented across multiple APA-supported studies: oscillation between hope and resignation. This oscillation is not abstract. It is observable, measurable, and consistently referenced in verified psychological literature. In the weeks leading to a clemency decision, inmates often experience a disrupted sleep, heightened vigilance, difficulty maintaining linear thought, intrusive anticipation, and moments of sudden emotional withdrawal. These reactions align with APA findings on stress-induced cognitive overload and the NIJ's data on inmates facing acute legal uncertainty. A frequently cited anonymized case in academic reviews describes a San Quentin inmate whose demeanor changed dramatically after his legal team filed a late clemency petition based on updated neuropsychological testing. Interviews conducted by licensed clinicians, summarized in research archives, not released publicly, showed alternating periods of hopeful engagement and abrupt silence, a pattern that Haney identifies as a coping mechanism developed in long-term confinement under threat of an irreversible outcome. During high-tension periods, inmates often establish rigid daily routines. Irving Irwin's research on prison adaptation explains this as a stabilizing mechanism. Structure becomes a psychological anchor when the future is unpredictable. Even small deviations, such as unscheduled attorney visits, updates from legal aides, or new forensic reports, can trigger spikes in anxiety. This is not simply fear. It is a cognitive response to a decision that lies entirely outside the inmate's control. Researchers call this external locus collapse. When personal agency shrinks to near zero, individuals experience emotional fragmentation, difficulty predicting outcomes, and intense self-scrutiny. Family communication becomes another psychological pivot point. Studies referenced in the Chicago Crime Lab's analyses show that contact with family during late appeals can temporarily stabilize an inmate's emotional state, but only if the communication is structured and consistent. Irregular updates can have the opposite effect, deepening uncertainty. In some San Quentin cases examined in legal psychology literature, inmates have shown a pattern of preparing simultaneously for two opposite futures, one where clemency is granted and one where it is denied. This dual-tracking behavior reflects a survival strategy documented in APA research on extreme stress exposure. The correctional environment responds to these shifts as well. Staff trained under CDCR guidelines recognize behavioral warning signs associated with acute psychological stress, and records show that individuals in clemency windows often require increased monitoring, not because they are volatile, but because uncertainty destabilizes normal coping mechanisms. The inmate's experience during this period is therefore not defined by a single emotion. It is a layered psychological event, a collision of hope, dread, memory, and identity, compressed into a shrinking window of time. The family impact, waiting for a decision that never feels final. For families connected to San Quentin's death row, the clemency window creates a psychological landscape defined by uncertainty, fragmented communication, and emotional suspension. Research from the American Psychological Association and the National Institute of Justice consistently shows that families involved in late-stage capital cases experience stress levels comparable to those observed in high-risk medical crises, yet with far fewer support structures. The emotional burden is magnified by the nature of clemency itself. Unlike appeals, which follow predictable legal stages, clemency decisions sit in a fluid space with no guaranteed timeline. Families may wait days, weeks, or even hours for an outcome that could permanently alter their lives. In academic literature focusing on capital case family dynamics, many relatives describe this period as living inside an unfinished sentence. Phone calls go unanswered while legal teams juggle filings. Updates arrive irregularly because attorneys are performing last-minute evaluations. Even mundane daily activities, work, school, appointments, become overshadowed by a persistent sense of emotional freeze. A representative anonymized case summarized in justice system research involved a San Quentin inmate whose mother received updates only through sporadic legal briefings. Clinicians who later interviewed the family noted symptoms consistent with APA-recognized stress responses: intrusive worry, difficulty concentrating, and disrupted sleep cycles. These experiences are not isolated, they are common across clemency cases. Family members also face the psychological tension of dual preparation. Much like inmates themselves, relatives often brace for both potential outcomes at the same time. The Chicago Crime Lab has documented comparable patterns among families dealing with high-stakes legal outcomes. Individuals begin preparing emotionally for relief and loss simultaneously, a coping mechanism designed to reduce the shock of either extreme. But the process is further complicated by communication barriers. CDCR regulations place strict boundaries around contact, and any increase in legal activity can tighten schedules or restrict access temporarily. This creates a cycle where families know change is happening but cannot fully see or participate in it, deepening the psychological strain. Support networks also shift under pressure. Some relatives withdraw from social environments due to stigma or fear of public judgment, a phenomenon described in multiple sociological studies on families connected to the criminal justice system. Others seek out religious or community-based support structures, using routine and ritual to regain a sense of control during the uncertainty. The emotional weight carried by families is therefore not a peripheral element of the clemency process. It is an integral part of the psychological ecosystem surrounding every last-minute petition. Their experience mirrors the broader theme of this documentary. When outcomes hinge on a single decision, human beings adapt in ways that reveal both vulnerability and resilience. The institutional pulse: how San Quentin prepares for uncertainty. Within San Quentin, the days surrounding a pending clemency decision create an operational atmosphere defined by heightened vigilance, procedural precision, and psychological tension. CDCR's publicly documented protocols for high-stakes legal windows show that staff responsibilities increase significantly even when the inmate's status has not yet changed. The uncertainty itself becomes a logistical variable. Routine inside the prison adjusts subtly but unmistakably. Supervisors review movement schedules. Psychological services stand ready for rapid evaluation if behavior shifts. Administrative teams coordinate closely with legal offices to ensure all required documentation can move at a moment's notice. This internal recalibration aligns with findings from correctional research institutions that track staff behavior under acute legal pressure. The Santa Cruz-based scholarship of Craig Haney, alongside NIJ-supported operational studies, notes that when outcomes remain unresolved, institutions often enter what analysts call a contingency posture, a period where normal procedures stay intact but are reinforced with additional monitoring and layers of verification. For correctional officers, the psychological demand is significant. Research published through APA's Forensic Division shows that officers in capital units experience a form of role compression, balancing professionalism with the underlying awareness that a single decision outside their control may radically alter an inmate's environment. Even though staff do not participate in the clemency review itself, they must maintain stability amid emotional volatility from inmates, families, and the defense team. In several San Quentin related academic analyses, officers describe these periods as quiet tension. Movement is orderly, but attention is sharper. Conversations are brief, clipped, and intentionally neutral. CDCR guidelines emphasize preventing conflict, diffusing stress responses, and maintaining predictability, because unpredictability inside the institution can trigger behavioral reactions among individuals already under extreme psychological pressure. Mental health professionals assigned to Capitol Housing Units monitor for sudden changes in mood, orientation, or behavior, patterns APA literature identifies as common in high uncertainty environments. Even minor shifts may be logged, not as disciplinary concerns but as clinical indicators that someone is struggling with the emotional weight of the pending decision. The administrative side of San Quentin likewise becomes a hub of activity. Legal coordinators cross-check records. Supervising officials ensure that documentation related to the inmate's history, behavior, and medical status remains accessible to external reviewers. This mirrors the NIJ's documentation of administrative responsibilities during last-stage legal processes, where accuracy and rapid access to evidence can directly affect petitions. Every element of the institution, from officers to clinicians to record specialists, operates with synchronized caution. Not because conflict is expected, but because uncertainty reshapes the psychological climate of a facility that relies on structure for safety and stability. Inside San Quentin, a clemency window is not merely a legal event. It is an institutional state of heightened awareness, calibrated to support safety, clarity, and procedural integrity during one of the most delicate phases in the American justice system. The evidence shift when new facts redefine the entire case. In the final weeks before a clemency decision, evidence can suddenly take on new meaning. Not because the facts have changed, but because the context in which those facts are evaluated becomes sharper, narrower, and more urgent. Verified research from the National Institute of Justice, the Innocence Project, and the Chicago Crime Lab consistently demonstrates that late discovered or newly interpreted evidence can radically reshape the trajectory of a capital case, especially when psychological factors or forensic limitations were overlooked during the original trial. These shifts fall into three primary categories identified in justice system literature: new scientific analysis, reinterpretation of prior evidence, previously inaccessible personal or developmental records. Each category can fundamentally impact a clemency petition at San Quentin. 1. New scientific analysis. DNA testing, updated neuropsychological evaluations, improved forensic techniques, and contemporary standards for eyewitness reliability often reveal insights not available during earlier appeals. The NIJ has published multiple studies confirming that forensic reevaluations conducted close to key legal deadlines can expose errors, inconsistencies, or developmental conditions that were not originally understood. In several anonymized San Quentin-connected cases referenced in academic literature, late-stage neurocognitive testing revealed impairments linked to early life trauma or untreated neurological conditions. These findings did not excuse the crime, but they reframed the inmate's developmental background and informed the legal question of whether the original sentencing fully accounted for psychological limitations recognized by APA standards. 2. Reinterpretation of prior evidence. Sometimes the evidence itself remains unchanged, but the understanding of its meaning evolves. Research referenced by the Chicago Crime Lab shows that defendants with cognitive vulnerabilities, trauma histories, or impaired memory often present with behaviors that were once interpreted as evasive, uncooperative, or inconsistent. Modern psychological frameworks interpret these same behaviors through a different lens, one grounded in validated mental health models. In San Quentin case analyses, attorneys have discovered that statements previously labeled contradictory aligned more closely with patterns of stress-related memory fragmentation described in APA literature. This shift can influence clemency evaluations by reframing the inmate's conduct at the time of interrogation or trial. 3. Previously inaccessible records. A recurring challenge documented in NIJ and Innocence Project reports involves missing or incomplete personal records. School files, childhood medical data, early mental health assessments, and social services records often surface only during the final stages of a clemency effort. One anonymized case cited in justice system scholarship involved a late-retrieved set of childhood medical documents that revealed long-term cognitive impairment never presented during the sentencing phase. Forensic psychologists who reviewed the material concluded that the inmate's developmental limitations were consistent with APA-recognized deficits in reasoning and impulse control. These findings became central to the clemency petition. The psychological impact of new evidence. The arrival of new evidence affects everyone in the clemency ecosystem. Defense attorneys experience a surge of procedural urgency. Families recalibrate their expectations. Institutional staff anticipate potential changes to housing, security, and movement. For the governor's legal advisors, who must evaluate every new piece of evidence through the filters of legality, precedent, and public accountability, late-arriving information introduces a cognitive tension documented in APA research. The conflict between analytic caution and ethical duty. And for the inmate, new evidence can trigger a sudden influx of hope, which psychologists warn is psychologically destabilizing when the future remains uncertain. Hope becomes both a lifeline and a stressor. The weight of a single document. In many clemency cases, a single record, one file, one evaluation, one expert statement, can become the pivot point for the entire process. It does not guarantee reprieve, but it reshapes the narrative that decision-makers must examine. These evidence shifts do not rewrite the past. They refine the truth. And in the final days of a clemency petition, truth, however late it arrives, can become the most powerful force in the room. The public eye, how media, advocacy, and perception influence clemency outcomes. Outside the gates of San Quentin, a second arena shapes the fate of last-minute clemency requests, the arena of public perception. This space, made of media coverage, advocacy campaigns, legal commentary, and community reactions, creates a psychological pressure point that verified research institutions have consistently identified as influential. According to analyses published by the National Institute of Justice, public sentiment can affect how decision-makers interpret late-stage evidence, not by dictating the outcome, but by altering the cognitive environment in which a governor or review board operates. When a case becomes highly visible, the decision carries broader symbolic weight, amplifying psychological tension among those responsible for granting or denying clemency. Media's role in shaping the decision environment. Media coverage surrounding San Quentin clemency petitions tends to surge during the final phase. While news outlets are bound by professional standards, the intensity of coverage can influence public expectation, create emotional narratives, and highlight aspects of the case that were previously overlooked. Verified research on capital case communication strategies, referenced in APA journals, shows that high-profile reporting activates what psychologists call reputational pressure. Decision-makers become acutely aware that whichever path they choose will be scrutinized through political, moral, and social lenses. In some well-documented San Quentin-related cases found in legal media analyses, journalists focused on systemic issues such as inconsistent forensic standards, childhood trauma, or cognitive impairment. This shift from crime-centered reporting to context-centered reporting mirrors a broader trend described in NIJ communication studies. Audiences increasingly respond to narratives about system failures rather than sensationalized violence. Advocacy groups as psychological catalysts. Organizations such as the Innocence Project, ACLU, and Death Penalty Information Center play a documented role in elevating clemency cases to public attention. They present verified data and contextual analysis, often emphasizing wrongful convictions, developmental disorders, or procedural shortcomings. While these groups do not determine the final decision, their involvement adds structure to public discourse. APA-supported studies show that strong advocacy narratives influence how the public evaluates fairness, which indirectly shapes the psychological climate in which governors deliberate. Public pressure can manifest in several forms: legal opinion essays, expert interviews, social justice campaigns, commentary from clergy and community leaders, statements from mental health professionals, online mobilization highlighting overlooked evidence. Each of these elements deepens the perceived importance of the decision, intensifying the psychological weight on the reviewing authority. Victims' families and the public narrative. A crucial, often misunderstood component of the clemency environment is the voice of victims' families. NIJ-supported research shows that their perspectives vary widely. Some oppose clemency, some support it, and others refrain from public commentary. When families choose to speak, their statements frequently become part of the broader public narrative. Legal scholars note that these voices introduce a moral dimension that decision-makers must weigh carefully, enhancing the emotional and ethical complexity of the clemency evaluation. Public reaction as a decision variable. Ultimately, public sentiment does not overturn evidence, but it shapes how evidence is interpreted. Psychology research referenced by the APA explains that under public scrutiny, decision-makers tend to seek cognitive consistency, favoring choices that align with perceived public expectations or minimize reputational risk. This does not imply bias or unfairness. It reflects a measurable psychological response to accountability in high-stakes environments. The tension of silent observation. For the inmate, the rise in public attention can be both empowering and destabilizing. Awareness that people outside the walls are discussing the case may cultivate hope. But hope, without clarity, increases emotional volatility, a pattern repeatedly documented in APA research on extreme uncertainty. For families, public attention can either create a sense of solidarity or a feeling of exposure. Some welcome the support, others retreat from the spotlight to avoid reactivating trauma. The public eye as a mirror of the system. In the end, the public's role in clemency is not about forcing an outcome. It is about revealing the values, fears, and expectations of a society confronted with the limits of justice. San Quentin becomes more than a prison in these moments. It becomes a focal point for national reflection, where psychology, law, and public conscience converge around a single, irreversible decision. The governor's final review, a decision made under maximum cognitive strain. As the clemency deadline approaches, the governor's office enters the most intense stage of the process. Verified analyses from the National Institute of Justice, APA's Forensic Psychology Division, and multiple peer-reviewed studies on executive decision-making describe this period as a convergence of legal scrutiny, ethical conflict, and acute cognitive load. Inside the governor's legal chamber, the team conducts what researchers term compressed deliberation. Every document, psychological evaluations, forensic reviews, institutional behavior records, victim impact statements, mitigation summaries, is re-evaluated with the awareness that time is no longer a resource but a constraint. The cognitive mechanics of final judgment. Decision-making under extreme time pressure follows patterns well documented in APA research. Narrowed attentional focus. A reduced openness to new information. Higher reliance on established precedent. Elevated fear of irreversible error. This psychological profile does not reflect incompetence. It reflects the weight of decisions that are permanent and public. Governors and their counsel must balance multiple verified frameworks. Legal standards for clemency. Constitutional boundaries. Psychological assessments from licensed experts. Institutional reports from CDCR. Historical data on similar cases. Public accountability impacts, as described in NIJ political behavior analyses. Each factor contributes to a mental environment in which clarity must be found despite conflicting pressures. The role of psychological evidence. In recent years, forensic psychology has played a more significant role in California clemency reviews. Verified research from Craig Haney and APA's psychological assessment literature highlights how cognitive impairment, trauma histories, developmental disorders, and long-term isolation can influence behavior during the original crime, interrogation, and trial. In several anonymized San Quentin linked cases referenced in legal scholarship, governors received late-stage neuropsychological reports documenting executive function deficits, early life neurological trauma, impaired decision-making capacity, a memory distortion due to chronic trauma exposure. These findings do not erase responsibility, but they raise a central clemency question. Was the original sentencing able to fully evaluate the individual's psychological condition using the scientific standards available today? The ethical dimension. A documented psychological conflict. APA ethics researchers describe executive clemency as a moral decision-making burden with no parallel. The governor must weigh irreversible consequences, verified scientific evidence, community expectations, fairness and proportionality, and the constitutional role of mercy. Legal scholars repeatedly note that this decision places the governor in a rare cognitive conflict. The duty to uphold law and order intersects directly with the duty to evaluate human vulnerability and systemic shortcomings. Internal dynamics in the final hours. Legal teams interviewed in NIJ-supported studies describe the environment as quiet but intense, hyper-focused, structured but emotionally charged. Documents are reread. Summaries are checked against original reports. Attorneys debate interpretations. Psychological findings are cross-referenced with legal precedents. Victim statements are reviewed with measured respect. In some cases, governors request additional clarifications from CDCR, psychological consultants, or forensic experts. In others, no new information is sought. The decision becomes a reflection of principle, precedent, and personal interpretation of justice. The weight of signing or not signing. The act of granting or denying clemency is formally simple. A signature, a brief statement, a legal order. But the psychological weight attached to that signature is profound. APA studies on executive responsibility show that decisions involving irreversible outcomes often remain psychologically impactful for years, even for experienced officials. Clemency is not a declaration that someone is innocent. It is a recognition that the legal system, human psychology, and available evidence sometimes intersect in ways that merit reevaluation. At San Quentin, this decision has shaped the lives of inmates, families, legal teams, and institutions, and it continues to shape the broader national discourse about justice and mercy. Mercy, psychology, and the human cost of final decisions. Clemency on death row is more than a legal procedure. It is a window into the deepest complexities of human psychology, institutional behavior, and moral judgment. From the inmate pacing in their cell, oscillating between hope and resignation, to the defense team racing against the clock, to the governor balancing law, ethics, and public scrutiny, every actor experiences the tension of finality under extreme pressure. Verified research, from Craig Haney's studies on confinement, the APA's forensic literature, CDCR reports, and IJ analyses, and Chicago Crime Lab findings, illustrates that clemency is not a simple act of mercy. It is a collision of evidence, perception, timing, and psychology, where even a single overlooked detail can carry immense weight. The stories within San Quentin reveal a system that demands endurance from inmates, families, staff, and officials alike. They show how human behavior adapts under extreme uncertainty, how hope and fear coexist, and how institutional and personal responsibility intersect at the edge of life and death decisions. For viewers, these cases challenge us to reflect on the values we place on justice, mercy, and the human mind's resilience under pressure. They remind us that every legal procedure carries a psychological footprint, not just for those inside the prison walls, but for everyone invested in fairness and morality. If this documentary gave you insight into the psychology of clemency, the human stories behind San Quentin's last-minute petitions, and the profound complexity of decision-making under extreme pressure, subscribe now. Stay informed, explore verified research, and join a community committed to understanding the human dimensions of justice. Because in the end, clemency is not just about the law, it's about the people it touches.